Question number 451. Which provision of the Indian Evidence Act stipulates that the fact of a woman being habituated to sexual intercourse will not be relevant on the issue of consent in a prosecution for rape or outraging the modesty of the said woman? Here correct answer is option B, that is section 53A of Indian Evidence Act. Question number 452. Which of the following statement is not correct? Option A, in rape, evidence of previous good character of the accused is relevant. Option B, in rape trial, evidence of character of the victim is not relevant. Option C, in a rape trial, evidence of previous sexual experience of the victim is relevant. And option D, none of these. Here correct answer is option C, that is in rape trial, evidence of previous sexual experience of the victim is relevant is not correct. Therefore, it will be the right answer. Question number 453. Under which of the section of the Indian Evidence Act bad character of an accused is not relevant? Bad character of accused is not relevant under section 54 of Indian Evidence Act. Question number 454. Under section 54 of Indian Evidence Act 1872, previous bad character is irrelevant but becomes relevant if the bad character of the person is itself a fact, the bad character of the person is itself a fact and issue, the bad character is evidence to a previous conviction, both B and C, and option E, none of these. Here correct answer is option D, that is both B and C. Under section 54 of Indian Evidence Act 1872, previous bad character is irrelevant but becomes relevant if bad character of a person is itself a fact and issue, the bad character is evidence to a previous conviction. Question number 455. A person is prosecuted for theft. Evidence is sought to be produced to prove that the accused is of a bad character and suspect of theft on several occasions in the past. Option A, bad character is relevant. B, the evidence was admissible. C, the evidence was not admissible. D, none of the above. Here correct answer is option C, the evidence is not admissible. Question number 456. The term character as explained in section 55 of the Indian Evidence Act means good and bad character, reputation and disposition of general nature, reputation formed on the basis of particular disposition, character in a criminal act. Here correct answer is option B, that is reputation and disposition of general nature. Question number 457. Character as affecting damages has been discussed in which one of the following sections? Correct answer is option A, that is section 55 of the Indian Evidence Act. Question number 458. In criminal cases, the fact that accused is of good character is relevant. B, in criminal cases, the bad character of the accused is always irrelevant. Here correct answer is option C, that is both A and R are true and R is the correct explanation of A. Question number 459. Consider the following statements. Statement first, in criminal proceedings, good character of the accused is always relevant. Second, in criminal proceedings, bad character of the accused is always relevant. Third, in a civil case, evidence of character of any persons concerned is always admissible. Fourth, a previous conviction is relevant as evidence of bad character. Which of the following statement given above are correct? Here correct answer is option C. The statement first and the statement fourth is correct. Statement first is related to in a criminal proceedings, good character of the accused is relevant and a previous conviction is relevant as evidence of bad character. Therefore, statement C is the right answer. Question number 460. Mark the incorrect statement. Options are: evidence is always allowed of facts which are necessary to introduce the main fact or some relevant fact. B, evidence can be given of facts which support or rebut an inference suggested by fact and issue relevant fact. Facts which contradict the inference of guilt will also be relevant. Circumstances of the situations are not relevant to proven identity. Correct answer here is option D. Here option D is incorrect, therefore it will be the correct answer. Question number 461. Which of the following statement given below is are correct? In civil cases, character to prove the conduct of imputed to a party is not relevant. In criminal proceedings, bad character of the accused is not relevant unless evidence of good character has been given. C, in criminal proceedings, previous conviction of the accused is relevant as evidence of bad character. All of these. Here correct answer is option D. Option D says that all the options are the correct. Question number 462. Relevancy and admissibility under the Indian Evidence Act are neither synonymous nor coextensive. Question number 463. Mark the incorrect statement. The term relevancy and admissibility are coextensive and interchangeable. The evidence must be relevant in order to be admissible. The facts which are relevant may not be admissible. That relevancy is the genus of which admissibility is a species. Here in this question, incorrect statement has been asked. The incorrect statement is the first statement, that is the term relevancy and admissibility are coextensive and interchangeable. This statement is incorrect, therefore it will be the correct answer. Question number 464. Indian Evidence Act deals with relevancy of evidence, reliability of evidence, admissibility of evidence. Select the correct answer by using the quotes given below. Here correct answer is option B, that is 1 and 3 only. Relevancy of evidence and admissibility of evidence. Question number 465. Exceptions to the rule against admissibility of hearsay evidence are provided in. Correct answer is option D, that is it provided under section 6 of the Indian Evidence Act, under section 32 and under section 34 of the Evidence Act. Therefore all of the above statement will be correct. Question number 466. Which statement is not correct? Some facts are relevant but not admissible. Some facts are admissible but not relevant. All relevant facts are admissible and all admissible facts are not relevant. Here correct answer is option C. Option C, that all relevant facts are admissible, is not correct. Whereas some facts are relevant but not admissible is correct. Some facts are admissible but not relevant is correct. And all admissible facts are not relevant is also correct. Question number 467. By the Information Technology Act 2000, amendment made in option A section 17, option B section 34, option C section 35 of Indian Evidence Act, and option D all of the above. Here correct answer is option D. Information Technology Act 2000 amendment made in section 17, section 34 and section 35 of the Indian Evidence Act. Question number 468. Which of the following pieces of evidence is not relevant under the Indian Evidence Act? Option A is accused of fraudulently delivering to another person a counterfeit coin which he knew to be counterfeit. Evidence is given that he was also in possession of other counterfeit coins. B. A sues B for damages done by B's dog which he knew to be ferocious. Evidence is given that the dog and the previously bitten X, Y and Z and that they had made complaints to B. C. A is charged with shooting at B with intent to kill him. Evidence is given that A had previously shot at B. D. A is tried for the murder of B by intentionally shooting him dead. Evidence is given that A was in the habit of shooting at people with the intent to murder him. In question number 468, correct answer is option D. A is tried for the murder of B by intentionally shooting him dead. Evidence is given that A was in the habit of shooting at people with intent to murder him. Here, this evidence is not relevant under Indian Evidence Act. Question number 469. The question between A and B is whether a certain deed is or is not forged. A affirms that it is genuine, B that it is forged. Here correct answer is option A only, that is A may prove a statement by B that deed is genuine and B may prove a statement that deed is forged. Option A is the right answer. Question number 470. A is accused of murdering B. The following facts are constructed in the case. An hour before the murder, A took B in his car to certain place. Second, A alone returned home. Third, A's clothes were found to be blood-stained. The evidence which takes into account the above mentioned facts is called. Correct answer is option A, that is circumstantial evidence. Question number 471. In the trial of murder of B by A, which fact is not relevant in the following? A was absconding immediately after the murder of B. A and B were seen together before murder. A borrowed rupees 10,000 rupees from B. On that day, A was in Bangalore while the murder happened in Indore. Here in this question it has been asked, in the trial of murder of B by A, which fact is not relevant in the following? Here correct answer is C. A borrowed rupees 10,000 from B is not relevant. Question number 472. A is tried for the murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is, here correct answer is option B, that is relevant. Question number 473. Tape recorded conversation is admissible in evidence if conversation is very important, conversation can save the culprit, conversation is relevant to the matters in issue but the voice unidentified, conversation is relevant to the matters in issue and the voice is identified. Here correct answer is option D. Tape recorded conversation is admissible in evidence if the conversation is relevant to the matter in issue and the voice is identified. Question number 474. Choose the true statement about propositions. Propositions are: evidence must be relevant as to the matters in issue, the best evidence must be given, it's all cases, circumstantial evidence cannot be admitted. Here assistants are: first and second are correct, third is incorrect, second and third are incorrect, first is correct, first and third are correct, second is incorrect, all are correct. Here correct answer is option A, that is first and second are correct, third is incorrect. First statement is Evidence must be relevant to the matters in issue. The best evidence must be given in all cases. Circumstantial evidence cannot be admitted. Here third statement is incorrect and above the two statements are correct. Question number 475. Which of the following pairs is not correctly matched? Admission by a person having any proprietary interest. Section 18 of the Indian Evidence Act. Confession made after removal of impression caused by inducement. Section 28 of the Evidence Act. Admission by persons expressly referred to by party to suit. Section 21 of the Evidence Act. Confession of an accused in police custody. Section 26 of the Evidence Act. Here correct answer is option C. Admissions by person expressly referred by party to suit is not correctly matched pair. Therefore, C will be the right answer. Whereas admission by persons having proprietary interest, section 18, confession made by after removal impression caused by inducement, section 28, and confession of an accused in police custody, section 26 of the Indian Evidence Act is the correct match. But in this question, incorrect match is asked, so option C will be the right answer. Now let us proceed to question number 476. Match list first and list second. Facts as effective fact in issue. Correct answer here is section 7. Facts forming part of the same transaction. Correct answer obviously is section 6, that is res gestae. Facts which constitute preparation for any fact in issue. Correct answer is section 8. Facts necessary to explain or introduce relevant fact. Here correct answer is section 9. Facts necessary to explain or introduce relevant fact. Therefore, by going through these options, the correct match will be option C. Question number 477. Match the following and tick the correct code. Section 7. Cause of relevant facts is the right match. Section 8. Motive of relevant facts. Section 11. Facts inconsistent with relevant fact. And section 14. Facts showing the existence of any state of body is the correct match for option D. By going through these options, the correct match will be option B. Question number 478. Which of the following pairs is not correctly matched? Option A. Relevancy of statements as to law contained in the law book, section 38 of the Evidence Act is a correct match. Relevancy of statements in map, charts, etc., section 35 of the Evidence Act is incorrect match. Therefore, B will be the right answer. Let us see other options also. Relevancy of certain evidence for proving in subsequent proceedings the truth of facts therein stated, section 33 of the Evidence Act. Relevancy of statement as to facts of public nature, section 37 of the Evidence Act. These both are also true. Therefore, incorrect one is B only. So, B will be the right answer. Question number 479 is again the match of the following. Section 46. Facts bearing upon opinion of experts. Section 47 of the Indian Evidence Act, opinion as to handwriting when relevant. Section 47A of the Indian Evidence Act, opinion to digital signature. And section 48 of the Indian Evidence Act is the last remaining option, that is opinion, existence of right or custom when relevant. By going through these matches, the correct match will be here option D. Question number 480. In Evidence Act, the facts of which judicial notice is to be taken are stated in. Correct answer is option C, that is section 57. Question number 481. Which one of the following sections of the Indian Evidence Act says facts admitted need not to be proved? Section 58. Question number 482. The court shall take judicial notice of foreign judicial records, national flag of a state not recognized by India, Stephen's Digest on Criminal Law, rule of road on land and in sea. Here correct answer is option D. The court shall take judicial notice of rule of road on land and in sea. Question number 483. A judicial admission operates as an admission, confession, a plea of ignorance, a waiver of proof. Correct answer here is option D, that is a waiver of proof. Question number 484. Under section 57 clause 1 of the Indian Evidence Act, the court shall take judicial notice of all laws in force in India, all laws including foreign laws, all Indian and Asian laws, all Indian and British laws up to 1950. Here correct answer is option A, that is all laws in force in India. Question number 485. Court can take judicial notice of that Amitabh Bachchan is a famous star, that M.F. Hussain is a veteran painter, that Bentham was a renowned jurist, none of the above. Here correct answer is option D. Question number 486. Consider the following statements. The proceedings of the Parliament or state legislatures of India are judicially noticeable facts. Rule of the road or land or at sea are not judicially noticeable facts. Criminal law enforcement in India is a judicially noticeable fact. Which of the above statement are correct? Here correct answer is option D, that is first and third. The proceedings of Parliament or state legislature of India are judicially noticeable fact and criminal law enforcement in India is judicially noticeable fact. Question number 487. Which of the following facts are required to be proved? All laws in force in the territory of India, public festivals and holidays notified in the official gazette, the rule of the road, none of the above. Here correct answer is option D, that is none of the above. Question number 488. Which of the following facts need not to be proved? Option A, oral evidence. Option B, documentary evidence. Option C, facts taken in judicial notice by court. And option D, relevant fact. Here correct answer is option C, that is facts taken judicial notice by court. Question number 489. Facts judicially noticeable may be proved, need not to be proved, need to be proved, none of the above. Here correct answer is option B, that is need not to be proved. Question number 490. Which facts under the Evidence Act need not to be proved? Option A, those which are deemed to have been admitted, those which are judicially noticeable, those which are actually admitted, all of the above. Here correct answer is option D, that is all of the above. Question number 491. The court cannot take the judicial notice of which fact? Option A, any news item published in the newspaper, the existence of the titles recognized by the Government of India, the territories under the dominant of the Government of India, the rule of the road and land or at sea. Here correct answer is option A. The court cannot take judicial notice of any news item published in the newspaper. Question number 492. The facts of which the court must take judicial notes included gazetted holiday observed by the Government of India, rule of road, neither A nor B, both A and B. Here correct answer is option D, that is both A and B. Question number 493. The term judicial notice under the Indian Evidence Act means notice given by the court, information given to the court to ask for evidence to recognize without proof something as existing. Here correct answer is option D, that is to recognize without proof something as existing. The term judicial notice under the Indian Evidence Act means to recognize without proof something as existing. Question number 494. Section 58 of the Evidence Act deals with formal admissions, evidentiary admissions, formal as well as evidentiary admissions, proof of facts by oral evidence. Here correct answer is option A, that is formal admissions. Question number 495. Facts which need not to be proved by the parties include facts which have been admitted by the parties or at or before the hearing, statements made on oath, any registered document, statements made in plaint or in written statement supported by affidavit. Here correct answer is option A. Facts which have been admitted by the parties at or before the hearing. Question number 496. Which of the following facts need not to be proved? Option A. The facts which are covered under the doctrine of res gestae, the facts which are written in the police statement, C. The facts which are admitted, and D. None of the above. Here in this question it has been asked which of the following facts need not to be proved. Here option C is the right answer. The facts which are admitted are need not to be proved. Question number 497. Under Evidence Act, which of the following facts need not to be proved? Option A. All laws in force in India, all public acts, proceedings of Parliament and legislative assemblies of India, all of them. Here correct answer is option D, all of them. Question number 498. Which of the following admissions are dealt with section 58 of the Indian Evidence Act? Admission in pleadings, admissions which can be implied from pleadings, admissions by the parties or agents at the time of the hearing, all of the above. Here correct answer is option D, all of the above. Question number 499. All facts except the contents of documents may be proved by primary evidence, secondary evidence, oral evidence, circumstantial evidence. Correct answer here is option C, that is oral evidence. Question number 500. Contents of documents under section 59 of the Indian Evidence Act 1872 can be proved by oral evidence, cannot be proved by oral evidence, may or may not be proved by oral evidence, can only be proved by oral evidence under the orders of the code. Here correct answer is option B, cannot be proved by oral evidence. Contents of the documents under section 59 of the Indian Evidence Act cannot be proved by oral evidence.